All right, I will call this hearing of the Judiciary, Finance, and Civil Law Committee to order. Today is March 28th, 2023. We do have a quorum present. First item of business is approval of the minutes of March 24th. Representative Curran, do I have a motion to approve the minutes?
So moved, Chair.
All right, the minutes before us. Any discussion? All those in favor, please say aye.
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 Opposed? The motion prevails. The minutes are approved. So we're going to go through, just had a question from one of our members. So the plan for today, this is different for those of us who've been serving the last couple of years. We have a separate policy bill from policy omnibus, from a finance omnibus. This is a good thing, and glad we're doing it that way. The policy omnibus we will mark up and vote on today, and then we will begin the walkthrough and taking testimony on the finance omnibus after that, and then we'll continue markup on Thursday. So the first bill on the agenda, I will move to recommend that House File 447 be placed on the general register. This is the policy omnibus, and then I will move the DE3 in front of the committee. So we also have some pre-filed amendments to the DE3. Representative Feist, I believe you have one of those, if you want to move it and describe it.
Yep. Thank you, Madam Chair. I would like to move the A2 amendment. It would just tighten up the language around officials eligible to officiate over weddings in Minnesota to make sure that it's only those elected to local, state, or federal office rather than like to their local condo board or something.
Got it. This was a clarification that was requested, and I think it's always good to be clear. Representative Johnson.
Chair Becker-Finn, Representative Feist, I thank you for the clarification, but I'm just wondering which, would this include soil and water conservation districts that are elected, and how far down the line does it go? Does it go down to township or?
Representative Feist.
Yep, thank you. Thank you for the question. So it's any local, state, or federal office. So it would, in fact, include state conservation water folks. We just want to make sure that it's people like elected to public office.
All right. Any follow-up, Representative Johnson? No. All right. All those in favor of the A2 to the DE3, please say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Now to the A1, Representative Frazier.
Thank you, Madam Chair. What the A1 does essentially makes the Public Board of Defense meeting subject to Chapter 13 open meeting law. I can tell you I was surprised. Someone asked me if this board was already subject to it, and I just thought it was. I've been working in the public sector for a long time, and I was unaware that this board, which we've heard members of the board testify to their policymaking task, was not subject to the open meeting law. So that's essentially what A1 does. It now subjects this board to open meeting law.
All right. And then Representative Frazier, to clarify, you're moving the A1.
That is correct, Madam
All
Chair.
right. Any discussion to the A1 to the DE3? All right. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. The amendment is adopted. And then we have one more amendment, but I believe Representative Carroll, you're moving the A3 amendment.
Yes, I am.
All right. Representative Carroll moves the A3 to the DE3. Representative Carroll, please tell us about the amendment.
Thank you. This is called healthcare mediation. It allows for resolution of concerns between a patient and a provider where there's been serious injury or death.
All right. Thank you, Representative Carroll. And for clarification, just an oversight on our part, this is the Representative Norris bill that was fully vetted in committee, intended to have it in the DE3, and just an oversight on our part. So thank you for moving that, Representative Carroll.
You're welcome.
Any discussion to the A3? All right. All those in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. The amendment is adopted. All right. Now that we got that taken care of, I believe Mary Davis and Nathan are going to walk through the DE3 as amended. I'm not sure who's starting. Mary? Okay. Ms. Davis.
Thanks, Chair and members. This is Mary Davis from House Research. I'm going to start with Article 1, which starts on page 1. It relates to civil law, property, and board membership. Section 1 provides that a statement of claims and other pleadings or filings made in conciliation court can be served pursuant to the rules of conciliation court procedure for forfeiture proceedings. Section 2 allows a person filing a name change after a divorce to go back to their maiden name without a criminal record check. Section 3, as well as sections 11 and 12 on page 10 and 11, prevent a person who has a felony conviction on their record from changing their name through their marriage license application and instead uses the existing name change statute. And Section 4 allows a person with a felony who's applying for that name change to not have to pay the court filing fee if they do it within 180 days of getting married. Section 5 allows a person to change their name after a dissolution of marriage without paying a filing fee or a national criminal history check, so long as they have a copy of the marriage dissolution court order and a certified copy of their birth certificate. Section 6 establishes that those who are aggrieved by a violation of a prohibition against assigning military pay can receive equitable relief in addition to damages, reasonable attorney's fees, and court costs. Section 7, as well as sections 9 and 10, make technical and clarifying changes to real property law. Section 8 deletes a reference to a statute that was repealed during the Minnesota forfeiture statute that was passed in 2021. Section 13, which is on page 13, requires the court to tell parties and attorneys in a divorce case to prepare a summary real estate disposition if there's real estate at issue in the divorce. Section 14 clarifies that the county is not responsible for determining if a summary real estate disposition was approved by the court when it's filed with the county. Section 15 and 16 make conforming and technical changes to real property law. Section 17 removes a prohibition on the survival of an action after a person dies. Section 18 amends the existing law on actions that survive after a person dies to allow the plaintiff or plaintiffs to recover for all kinds of damages. And Section 19 allows a claim that a person had before they died to continue after they died for all damages, not just special damages, so long as a suit is brought within 6 years of the act or omission or within 3 years of the person's death. Sections 20 to 23 make technical and conforming changes to real property law. Section 24 permits service of a complaint challenging asset forfeiture to be made on the prosecuting authority by certified mail, consistent with the parallel provision relating to DWI forfeitures. Section 25, along with the A1 amendment, increases the membership of the State Board of Public Defense from 7 to 9 members and provides that the board is subject to the open meeting law. Section 26 repeals the provision of law related to unattended animals and repeals a provision of law related to the forfeiture of property that's very, very old. Paragraph B of that repealer section repeals 504B.305, which required landlords to provide notice to tenants regarding a statute that was repealed, again, during the revision of the Minnesota forfeiture statutes in 2021. Article 2 relates to construction contracts. Section 1 provides a definition for indemnification agreements. Section 2 adds a definition of promisee for the sections of Chapter 15 relating to public construction contracts. Section 2. Section 3 limits the applicability of indemnity agreements in public construction contracts to negligent or intentional acts for the purposes of strict liability imposed by environmental regulations. This section also makes requirements that one party in a contract provide insurance for another party for negligent or intentional acts, and that if you do that, that they're void, and it provides specific exceptions, including contracts for work near railroads. Section 4 adds more definitions to clarify the terms. It adds defend to the definition of indemnification agreement. Section 5 removes project-specific insurance from the list of exempted insurance requirements in private construction contracts. And Section 6 provides the effective dates for the articles for this article. Article 3 relates to civil rights law. The majority of the sections in this article relate to removing the term gender from the definition of sexual orientation, and it creates a new definition of gender identity for the Minnesota Human Rights Act. So the majority of these sections insert the newly defined term gender identity into the existing statutes related to protected classes. So I'm just going to highlight the other sections in this article. Section 14 prevents employers, including labor unions and employment agencies, from requesting a job applicant's pay history. This provision does not prevent a job applicant from volunteering their past pay if the employer does not prompt them or require them to provide it, and it doesn't apply if the job applicant's pay history is a matter of public record. And it also doesn't apply to certain bargaining agreements. Section 20 amends a section of the Minnesota Human Rights Act providing specific instances of discrimination against a person with disabilities to include that places of public accommodation must provide closed captioning television when the television is provided at that location to others. Near the end of this article, section 29 and 30 relate back to that new definition of gender identity. And section 29 removes an exception that allows homeowners to discriminate on the basis of sexual orientation when renting a building that has 2 units. Section 30 repeals an existing law that allows discrimination on the basis of sexual orientation related to hiring employees for organizations that provide services to youth, and repeals a section of the Human Rights Act related to the construction of the law. Nathan Hopkins is going to walk through the data article.
Mr. Hopkins.
Madam Chair and members, Article 4 is the data practices article. It begins on page 40 of the DE amendment. The first section of the article addresses when the Commissioner of Administration issues advisory opinions. It strikes a fee requirement for an advisory opinion. It clarifies notice requirements for when the Commissioner decides an opinion will not be issued, and it extends the deadline for filing for issuing an advisory opinion from 20 to 50 days. Section 2 of Article 4 deals with political subdivision licensing data. This is a new section added to the Data Practices Act. It classifies as private or non-public tax returns or bank account statements submitted to a political subdivision as part of an application for a license. It also imposes a destruction requirement for certain data. On page 42 of the DE, that's section 3. This deals with educational data. The changes to this section are all on page 44. This is adding 2 new paragraphs to this section, essentially allowing 2 new instances in which private educational data can be disclosed. The new paragraph R allows a student's contact information to be disclosed to a public library for purposes of issuing a library card to the student. The new paragraph S allows educational data to be disclosed to tribal nations about tribally enrolled or descendant students. Section 4 on page 44, this deals with directory information. It prohibits an educational institution from designating a student's personal contact information as publicly available directory information. Finally, Section 5, the last section in Article 4, animal premises data. This is on page 45. This requires the Board of Animal Health to provide public access to data that identifies the location of registered cervid farms. Madam Chair, Ms. Davis will continue the rest of the
Ms.
article.
Davis.
Thank you, Chair and members. Mary Davis from the House Research Department. Article 5 relates to notaries public, and sections 1 to 4 allow notaries who are licensed in Minnesota to register to perform marriages, and it also allows past and current elected officials in Minnesota to perform marriages for both the notaries and the elected officials if they register with the county to be a marriage officiant. Article 6 is from the A3 amendment to the D3. This creates an open discussion process between a patient and a healthcare provider. It provides that a patient who is injured or died at a healthcare facility or under the care of a doctor or provider, that they can be sent notice and asked to engage in an open discussion process. It provides the patient with information about their legal rights, or allows that the patient can request to enter the open discussion as well. The sections here provide that the process is confidential except in certain instances related to a court proceeding. And it also has the law sunsetting in 2031. And Chair and members, that is the bill.
All right. Thank you, House Research. We did have a couple people signed up to testify ahead of time, so we'll move on to public testimony. I have Brooke Bordson, and then Cameron Boyd is on deck. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. Thank you for the opportunity to testify today. My name is Brooke Bordson. I'm with the League of Minnesota Cities, which represents 837 cities across the state. My comments will refer to Article 2 in the DE amendment related to construction contracts. There's also a letter in your packet detailing concerns from public owners. Public project owners support having contracts that are fair to all participants in the construction process, and we support having parties bear the costs of their own negligence and not being responsible for indemnifying or defending the negligence of others. However, we are concerned that the change in this bill will have unintended consequences that pose a risk to public project owners that increase the likelihood and costs of litigation management for public projects. The proposed language requires that the underlying claim be attributable to a contractor for the duty to defend to apply, but the allocation of liability is determined at the end of a legal process. In the meantime, a city or other public entity will have to provide a defense even if they do not participate in the work or have a causal relationship to the work done and the injury or damage claimed. Public owners have also raised concerns about the insurance language in the DE amendment, which weakens project owners' ability to tailor insurance coverage as necessary to protect publicly funded projects. This section has been modified in the Senate version of the bill, and we would request consideration of that language in House File 447 as well. The public owner representatives will continue our ongoing discussions with proponents and stakeholders and work to find a solution to address the concerns of subcontractors while protecting taxpayer dollars. And thank you again for the opportunity to testify, Madam Chair.
All right, thank you for your testimony. Cameron Boyd and then Jim County on deck. When I tell you you're on deck, if you want to come sit on one of these chairs closer to the testifier table, that would be great. All right, please introduce yourself and go ahead with your testimony.
Chair Becker-Finn, members of the committee, my name is Mitchell Killian. I'm sitting in for Cameron Boyd, who's out ill today. So I'm the Vice President of Governmental Affairs with the Airports Commission. I know you've heard a lot about this bill over the last while, but I'd like to shine a light on a couple of key issues to get you thinking about before this moves forward. First of all, during testimony, every time that the bill was up, we heard those in support of the bill say, in current environment, they have to bear all risk of the projects. And I just need to clear that up because that's just not accurate. There's state laws that say we can't sign away our liability in contracts, that MAC and other public owners and other building people that are building buildings cannot sign away their liability. So when you hear that they bear all risk, that's just not accurate. And so we need to make sure that that's cleared up, which gets us focused on what this bill does, which is the duty to defend. In our current practice, we do put in our contracts, and so do private businesses and other local units of government put into their contracts that say, look, if there's a third-party lawsuit, there's going to be a requirement that there's a duty to defend on us in that case. An example that we have is at the end of a project, a landscaper is finishing up a project, they shoot a rock out of a trimmer or something, and it hurts somebody. Everybody in sight gets named by the lawsuit, right? In our case, with the Metropolitan Airports Commission doing $200 to $400 million worth of work, we expect that contractor to defend that suit. And that's the way it works. And that they go in and they defend it on our behalf and on everybody's behalf, and that's the way it works. Today, I want to make sure that you understand that. We don't have any examples where somebody went in and defended a case like that and it turned out to be our issue. Again, we don't have any cases that are examples that say it turned out to be the Metropolitan Airports Commission's problem where someone else defended it. If this law passes, what's going to happen is that same lawsuit will get filed, and our in-house attorneys are going to have to fire up. We're going to have to fire up our out-of-house attorneys, and we're going to have a whole bunch of costs running around because we're named in the lawsuit. So for the committee, because it's a finance committee, I don't think that the fiscal note really takes into account all the local units of government that are going to be drug into these lawsuits.
Mr. Killian, if you could wrap up, and this is a policy bill, so there isn't, not before us.
I just think that there's some pieces that really need to be cleared up about the piece of it, because there's no examples,
Yep.
again, where there were.
Mr. Killian, I know you're filling in, but we let everyone know they had 2 minutes, so thank you. Mr. County.
Good morning, Madam Chair and members. My name is Jim County, and I'm Deputy Chief Counsel at MnDOT. And I won't duplicate comments about the duty to defend. I just want to briefly address the insurance provision this morning. Current state contracts do not require a contractor or subcontractors to insure the state for the state's own fault or negligence, and there are no plans to change that. But we believe the insurance and the provision in the bill is overly restrictive, and it potentially hinders our ability to get the right insurance coverage for a public project. In the other chamber, the proponents offered an amendment to the insurance section that we believe improves the insurance section and ensures that the clauses in our state contracts will continue to remain enforceable. So we hope to have some conversation around that insurance language as the bill moves forward. Thank you for your time, Madam Chair and members.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on the DE3 omnibus bill before us? All right, please introduce yourself and proceed with your testimony.
Thank you, Madam Chair. Edward Reynoso, representing Teamsters Local 320. I just want to point out our solid support of expanding the Board of Public Defense. This will provide a better transparency with the amendment and will provide a more robust voice for marginal communities and BIPOC communities. Thank you.
Thank you for your testimony. Anyone else from the public wishing to testify on the DE3? All right. Not seeing any, we will move on to member discussion. Representative, I mean, it's kind of your job. Representative Scott.
We're kind of a talkative bunch this morning. Just a few comments on the bill, Madam Chair, and thank you for having two separate bills. I'm very appreciative of that, and it is the way things should be done. It starts out with a bang with my bill on forfeiture, the forfeiture piece, which is a bipartisan piece. But yeah, I have some issues with the human rights section and so forth. And I do think that, I'm interested in the testimony this morning that, there's still some opposition to the one section about the indemnification piece. And so I don't really have a dog in that fight or whatever the expression is, but I do hope that if there's some areas that can be where more peace in the valley can be come to, then then that will happen as this proceeds and goes into a conference committee or whatever. So I'll be encouraging my members to vote no today, but I do think it's overall not a terrible bill. So.
I'll take that endorsement. Representative Johnson.
Chair Becker-Finn, again, thanks for dividing these up the way it should be done. I do have some concerns in the bill. Representative Scott brought up a couple, but I'm also concerned about the Board of Public Defense. This is a board that should not be politicized, and now with the governor having the ability to appoint people to have majority, it makes it politicized. Our judiciary system should never be politicized, and with the way this is set up and doing this now, we have now made it a political appointee that is controlling the board, and the executive branch is now controlling it as well. So with that, I cannot support this bill at this time, but there are some good things in this bill.
Thank you. And I will note that the Supreme Court justices are also political appointees. Representative Johnson.
Chair Becker-Finn, you are wrong with that. They are elected. Unfortunately, we've got to the point which this body needs to fix, is that due to retirements and sometimes forced retirements by age, we're allowing the governor to appoint. But the people, by our Constitution, elect our Supreme Court judges.
Representative Johnson, I am not wrong. The governor does the initial appointments, and yes, then they are on the ballot, but we cannot pretend that there is not a role to play on the executive branch. I will also note that, one thing that we don't talk about is that we, as the legislative branch, do not have the check on the appointment of justices the way that they might at the federal level. So I do think it is important that we're honest on both sides of that. Any further discussion to the bill, members? All right. So with that, I will renew my motion to adopt the DE3 amendment as amended. All those in favor, please say aye. Aye. Opposed?
No.
The motion prevails. The amendment is adopted. Now on to the bill, now that we've amended all the amendments. I will renew my motion to recommend that House File 447 as amended be placed on the general register. All those in favor, please say aye. 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 Opposed?
No.
The motion prevails. All right, moving right along to House File 1580. I'm not going to move that, but you do have the bill and the DE in your packets. We'll be moving that and moving some, if amendments are filed, moving some amendments and doing the markup of that bill on Thursday. So with that, we will move on to the walkthrough of the DE4 amendment, our omnibus finance bill. All right, Mr. Walls, I believe you're starting. All right, please go ahead.
Madam Chair, all members should have a spreadsheet in their packet along with the bill and DE amendment. I'm going to start at the logical place, the top of page 1. For those of you who perhaps are unfamiliar with the spreadsheets that are customarily handed out in this committee, each of the little boxes represents an agency or a program within an agency. The top line would represent the base, then we have the additions, and it totals to the suggested funding level of the committee at the bottom.
And Mr. Walls, I'm just going to remind our new members that there should be a ruler in your packet. That's the whole reason that ruler has been in there all session. Mr. Walls.
So, Madam Chair, beginning at the Supreme Court on line 3, we see the Supreme Court general fund base. The House columns are on the right. And the base for the Supreme Court is $43,384,000. To that, we add funding to give the courts enough money for raises, salary increases, and insurance increases that would support 4% each year. And then the new total for the Supreme Court becomes $44,943,000 in fiscal '24 and $46,703,000 in fiscal year '25. Moving down to civil legal services, they come in with a base of $18,198,000. We give them a substantial increase on line 16, $10 million in fiscal year '24 and $26 million in '25, growing to $27 million in fiscal year '27. And that brings us to the new totals on line 18. And then on line 20, since civil legal services is part of the Supreme Court, you add those two together, and the totals for the Supreme Court are $73,706,000 in '24 and $91,556,000 in fiscal year '25. Madam Chair, moving down to the Court of Appeals, their base is on line 22. To that, we add funding for pay increases of 4% per year on line 26, and we add $134,000 a year to bring their law clerk base pay up to $69,000. And Madam Chair, on line 30, you can see the total for the Court of Appeals. Moving down to the district courts, they come in with a base of $333 million a year. To that, we add funding for salary increases and insurance. The salary increases of, again, 4% per year. We add in fiscal year '24 on line 37, one-time funding to deal with a court case backlog of $8.4 million per year. On line 38, the mandated psychological services data, just shy of $2 million per year, is added to their base. On line 39, there's funding for new treatment courts of $422,000 per year. Below that, we have a one-time expenditure of $7.4 million for courtroom technology enhancements. On line 41, we have an addition to their base for court interpreter payment rate continuation. This was an item that was funded for 2 years in '21 and would expire without this funding, and so we have included the funding to keep the rate at its current level. On line 42, we have additional jury pay, which was House File 1580. It's $2.6 million a year. I believe that brings up jury pay from $20 a day to $50 a day. And on line 43, again, within the district courts, this is the funding to bring up the base rate for law clerks. And then on the final line, we have the total for the district courts. Moving on to the top of page 2, the Guardian Ad Litem Board. We have their base of $22.8 million on line 47. We add to that an initiative called Maintain Core Guardian Operations, which includes salary increases, any increases in rent, and insurance, and their total is on line 56. On line 58, we have the tax court. The tax court's general fund base of $1.8 million per year. On line 61, we add insurance and salary increases. On line 62, they had an initiative for case management e-filing for $75,000 a year, bringing their new total to $2.1 million per year on line 65. On line 67, the Uniform Laws Commission, base of $100,000 per year. We add $15,000 to that base for maintaining their service levels, bringing them to $115,000 per year. On line 73, the Board of Judicial Standards, $586,000 per year is their base. On line 75, there's a small addition there of $69,000 in the first year and $59,000 ongoing, and their new totals on line 78. Madam Chair, on line 80, the Public Defense Board came in with a base of $111,409,000. There's a substantial addition for what they call meeting challenges facing public defense. This would fund some salary increases, some money for retention, and also, I believe, for some new attorney positions. That is an addition of $42,725 the first year and $42,725,000 the first year and $52,951,000 the second year. Madam Chair, as members are aware, a bill similar to this passed the House floor. It was not taken up by the Senate, so the funding is included here. And on line 88, the new totals for the Board of Public Defense. Madam Chair, moving to page 3, we have the Human Rights Commission. Their base of $5.5 million a year is on line 90. We add to that on line 93, funding for salaries and insurance. On line 94, we have transformational investment in enforcement. This is 16 new positions and an increase of $1.5 million. We have a civil rights mediator stipend on line 95 at $20,000 for 2 years. On line 96, we have the prohibit source of income discrimination in housing. This is for 2.75 new positions to enforce these restrictions, and it is $383,000 in fiscal '24 and $394,000 in fiscal year '25. On line 97, we have the discrimination and hate data gathering, which would be an additional 2 positions, and $395,000 the first year and $250,000 ongoing for that provision. And on line 100, the new total for human rights of $8.4 million in '24 and $8.8 million in '25. Madam Chair, the Board of Appellate Counsel for Parents is a new board established by House File 922. So on line 104, you see the money to establish the board, which is $659,000 in fiscal year '24 and $1.56 million ongoing. Madam Chair, on line 108, the Competency Restoration Board. This was something that was established last year. The spreadsheet shows the funding, but it is not contained in this bill. It is just counted against our target. You'll see $250,000 in fiscal year '24. This actually was appropriated in fiscal year '23. It passed in House File 121 and was signed by the governor, so that is current law, and it's just here to reflect that it is counted against the target of this committee. On line 115, we have an appropriation for the Department of Human Services. The dollars are shown on line 117. That is House File 774. That is to purchase and I believe renovate in the Kozlowski bill for First Witness Child Advocacy Center in Duluth. Again, that is $1.5 million one time. On line 122, we have the revenue changes, of which there are two. On line 124, House File 305, the loss for no longer charging an online document fee. Those revenues currently go to the general fund. To no longer charge the public for those document fees would cost the general fund $265,000 in '24 and $284,000 in '25 and ongoing. Madam Chair, on line 125, we have House File 1414. It is the Ramsey County fine distribution. They are treated differently, I believe, than Hennepin County, and this is to put them on the same footing. This would allow Ramsey County to keep a slightly larger portion of the fines that are levied in Ramsey County and tried in Ramsey County courts. And so the revenue loss to the general fund is $91,000 in fiscal year '24 and $121,000 in fiscal year '25 and ongoing. Madam Chair, on line 131, it just is the total spending by year of all provisions in this bill. This counts spending and the loss of revenue. It reflects a net impact of the general fund, and we are at our budget resolution prescribed target of $1,355,108,000 for the biennium. And Madam Chair, that completes the walkthrough of the spreadsheet.
Thank you, Mr. Walls. Now it's Mr. Johnson.
Madam Chair, members, Ben Johnson with House Research. I'm going to make a few brief comments on Article 1, particularly for the newer members, and then walk through Article 2. Article 1 looks different from what many new members have ever seen before. This is an appropriations article. You'll notice that the formatting is different from a standard bill formatting. The appropriation language is different. It's written in tables. The language that appears toward the left of the page in the skinny paragraphs is what is referred to as rider language. Rider language is good for 2 years. So you'll see some riders that were not specifically mentioned by Mr. Walls during his walkthrough because they're only good for 2 years. They are what we refer to as boilerplate typically. So for example, on page 1, there's a contingency account for the Supreme Court operations. $5,000 of the total appropriation goes into that. That's not a new appropriation to the Supreme Court or any change. That's just providing that $5,000 of the total appropriation goes into that account. There are a few others scattered through Article 1, but if you didn't hear a reference to them, it's because they're this sort of standard boilerplate that we put in every single year. One brief comment on the number that is in the fiscal year 2025 column at page 2, line 7. You'll see it currently says $48,853,000. That's an incorrect number. The number in the spreadsheet is correct. We have an amendment drafted already to correct that. And on page 3, lines 12 and 13, you'll see a reference to the Court of Appeals where there should be a reference to the district court. Again, we have caught that error, and there's already an amendment drafted that will be offered to correct that technical error. Madam Chair, I'm going to move now to Article 2 and walk through that briefly. Article 2 consists of only a few different bills that have a fiscal impact that this committee has heard this year, so I'm going to spend very little time on them. The first section, which begins on page 5 at line 6, is from House File 922. This is the provision that creates a new statewide office of appellate counsel and training. That provision goes on for several pages, but it is unchanged from what was heard in committee. The next section is on page 10, beginning at line 1. This is the elimination of the $8 fee for uncertified copies of documents from the courts. Again, this is unchanged from what the committee heard. Section 3, which is on page 11, starting at line 19, is the human rights provision that requires the Department of Human Rights to solicit, receive, and compile reports from community organizations and others regarding incidents that members of the community believe are motivated by bias. Again, unchanged from what was heard in committee. This was from House File 181. On page 13, beginning at line 29, is the provision related to the court fees and fines for Ramsey County. Mr. Wall's description was not 100% accurate, so very briefly, Hennepin County remains an outlier. Hennepin County receives a larger percentage than any other entity in the state. The issue for Ramsey County was that they receive 50%. Everyone else except for Hennepin County receives 2/3 of that revenue. This would put all of the municipalities in Ramsey County in that 2/3 category in line with everyone else in the state. Hennepin County remains the outlier.
I will correct both of you that St. Paul gets a bigger cut than the other cities in Ramsey County. So this is to bring Ramsey County suburbs, which I see a lot of folks at this table represent, including myself, represent Ramsey County suburbs. So we got there. Good job, team.
That's right. That's what I was about to say next, in fact. I was going to
Thank you,
say
Mr.
St. Paul
Johnson.
is the outlier and does receive 2/3 currently. The final section, which is on page 14 at line 21, is establishment language related to that statewide Office of Appellate Counsel and Training. This has been changed slightly from what was heard in committee based on input from the Department of Administration, and I believe also from Management and Budget. They wanted a slight shift in who would have this responsibility, and so this language now shifts that responsibility to the Management Analysis and Development Division of MMB instead of the Department of Administration. Madam Chair, that does complete the walkthrough.
All right, thank you. And thank you to all of our nonpartisan team for helping us get this draft and proofreading everything. And folks don't realize how much work goes in behind the scenes and over the weekend by our nonpartisan folks to get these bills in front of us. So thank you. Moving on to public testimony. I do have some folks signed up ahead of time. I've got Danielle Walzak. And then I have Judge Jim Moore on deck. Welcome to the committee. Please introduce yourself and proceed with your testimony.
Well, thank you, Madam Chair. Thank you, committee members. My name is Danielle Shelton-Balchak, two last names. I'm the Executive Director of Mid-Minnesota Legal Aid, and I am here on behalf of my civil legal service partners to say thank you for consideration of this bill. As you know, CLS willingly provides legal services to low-income individuals, regardless of race, creed, ethnicity, gender, and ideology. This appropriation would allow us to increase staff retention, stave off turnover, increase capacity to give more services to your constituents across the state of Minnesota. And as you know, CLS is here to provide access to justice for low-income persons in need, be it in domestic, employment, education, housing issues, and others. The impact of this appropriation would not only be direct to your constituents and civil legal services, but create a positive ripple effect in other areas. For example, in helping moving cases more expediently through the court system and potentially decrease cases because claimants have representation, as well as it would increase community outreach and community-based services. To conclude, I'd like to thank you all for your consideration of this appropriation again, and specifically I would like to thank the Chair Becker-Finn for her leadership and support of of CLS. Thank you.
Yeah, thank you for your testimony. Judge Moore, please introduce yourself and proceed.
Thank you. Madam Chair, members of the committee, my name is Jim Moore. I'm a district court judge in Hennepin County, the 4th Judicial District. I'm here today representing the Minnesota District Judges Association. Over the last year or so, I've been the chair of the Law Clerk Committee for that organization. As I think you all know, each of our members, more than 300 judges, each take an oath to uphold and support the Constitution of the United States and the Constitution of the state of Minnesota. And we have a shared mission to provide justice through a system that assures equal access for fair and timely resolution of cases and controversies. But when you boil that lofty language down to its nub, what you have is a single judge dealing with a case. And it's that judge and the lawyer they hired to be their law clerk in chambers who are working through to understand the issues and to make the best decisions they can on each issue in each case. The dockets that they're going to be facing are typically going to be hundreds of cases and thousands of issues at any given time. A judge cannot know it all, and a judge cannot do it all. We need good help in chambers to do our jobs, or we will fail. And when we fail the entire state. And I'm sorry, I've lost my place in my notes.
It happens to the best of us, Judge.
Not used to having a time limit either. I usually get to impose. The District Judges Association, as you've already heard, conducted a survey of our members, and they identified a problem across the state. In addition to that, the board, and I don't think you've heard this, the board of the Judges Association voted unanimously to support increased pay for our law clerks because of the problem that we are having recruiting and retaining good people in chambers. If it were your case before a judge, wouldn't you want the best legal minds working with that judge to make that decision? I know I would. I do. But we don't have that across the state. We have judges working with law clerks that they would choose not to hire if they had a choice. We have judges working without law clerks. And the system is broken. We need to fix it. So on behalf of the organization, I want to thank you all for what you have done to make this issue a priority. I want to thank you as well for supporting staff and judge pay increases. And I recognize that this is a tough year, and there are lots of demands on you. But I think that the issue of law clerk pay is existential for our system. And so for what you have done and what you will do, I want to thank you on behalf of our organization, for the judges who are here, for the judges who will come after us, but also on behalf of the citizens of the state who deserve and need a justice system that can meet the demands placed upon it. Thank you.
Thank you for your testimony. Next up, I have Ed Reynoso, and then I have Gerard Bodell on deck. Welcome back. Please introduce yourself and proceed.
Good morning again, Madam Chair, members of the committee. My name is Edward Reynoso. I want to thank you for the opportunity to testify today. I represent Teamsters Local 320 as the Director of Political and Legislative Affairs. On behalf of over 1,100 Teamster members these budget proposals will impact, we wholeheartedly thank you. Your support for the guardian ad litem program is vital as it safeguards at-risk children's best interest in juvenile and family courts. Your strides in addressing public defense challenges like salary parity, manageable caseloads, and retention will make our justice system more effective and equitable. Your attention to the district court budget, focusing on case backlogs, wage disparities, and retaining skilled personnel helps create a more streamlined court system. We believe your dedication to tackling these critical issues will foster a more just and equitable justice system. Thank you.
All right, thank you for your testimony. All right, Mr. Bodell, and then I have Rich Gehrman on deck. Please introduce yourself and proceed with your testimony.
Good morning. Thank you, Chair Becker-Finn and committee. I'm Gerard Bodell. I'm a volunteer guardian ad litem in the 4th Judicial District. I'm also the volunteer board president of CASA, Minnesota, an organization that screens and trains and recruits volunteers, community volunteers. I'm here today to support this funding bill, but also ask that you earmark $450,000 within the bill to build back and sustain the community volunteer portion of the program. The guardian ad litem role was created over 40 years ago with community volunteers, but it will die today without your action. So yes, let's pay employees more. We need to, but this alone won't solve our problems. Recruiting talented people in child welfare space is at a crisis level, locally and nationally. The open positions and the turnover, it's staggering, right? We cannot fill any position in our economy, let alone these guardian ad litem positions. Employees take up to 30 cases, and volunteers take 3 cases each. We know that 30 cases is not sustainable and it's not good child welfare. Not even 20 cases is sustainable and not good child protection. So why does this matter and why is this urgent? Well, Minnesota's workforce is not expected to grow to meet any of these needs. On average, 2 children are dying every month while they're in child protection. Child protection is where they should be protected. No one should be dying. Volunteer guardians, they offer a solution. Together with the paid employees, we add more resources, and those resources become more plentiful for everyone involved. So community volunteers also offer a diversity and inclusion strategy, providing more opportunities for the guardians to look like the children we serve. The volunteer model is strong. There's 98,000, like me, volunteers trained nationally right now in 49 states, plus the District of Columbia.
And Mr. Bodell, I'll have to ask you to wrap up.
Okay. So in conclusion, many volunteers go on to do great things. Denise Graves, a former volunteer, she funded and opened Paris Hill Housing Community Project supporting fosters in Hennepin County. And then Michael Tickinen went on to be a child welfare author and speaker.
Mr. Bodell, thank you for
your... Representative Claiborne.
Mr. Bodell, we told you that it was going to be timed. We have posted the numerous documents that you sent to us. We're going to move on.
Thank you.
Mr. Gehrman, please introduce yourself and proceed.
Madam Chair and members of the committee, I'm Rich Gehrman. I'm the Executive Director of Safe Passage for Children of Minnesota. We, too, are a volunteer-based child advocacy organization, and I'm here to support Mr. Bodell's request that some portion of the guardian ad litem budget increase be focused on CASA, supervising CASA volunteers. We are very concerned about the decision by the state guardian ad litem program to end CASA through attrition. We understand that 49 states plus the District of Columbia have CASA programs and have managed to figure out how to manage those volunteers, so we are unsure why we can't do that as well in Minnesota. I have many years of experience myself, over 2 decades, in supervising county and state human services budgets. And one of the things I've observed is that many of these proposals, and this is what I observed at the Guardian Ad Litem Board, are focused on the cost of supervision or managing programs, but often the benefits are not also included, and that changes the picture significantly when you include benefits. And CASA volunteers bring many benefits to Minnesota. For one, they raise awareness about the importance of child protection and foster care and of the resources that social workers need to do their job. Guardians also are focused specifically on advocating for the child, which in our experience is a really important perspective in the courtroom. And as Mr. Bodell said, it's an additional avenue for diversifying the team that interacts with families and children. So our organization has had many volunteers who are also CASA volunteers, and we found them to be dedicated and very knowledgeable advocates for children. So we encourage you to consider Mr. Bodell's request that some portion of this increase be focused on supervising CASA volunteers. Thank you very much.
All right, thank you for your testimony. Are there any other members of the public wishing to testify? All right, not seeing any. We we do have a little extra time for discussion if there's member discussion to the bill. Oh, Representative Finke.
Thank you, Chair Becker-Finn. And this may be a question. I am one of the much discussed first-term members in this committee. So I'm just trying to figure out a little bit of level setting on how these bills are talking to each other and the work kind of sort of communicates across. Specifically, I was thinking about the funding for the Human Rights Commission and how we have the discrimination and hate data gathering provision. And then we have, I believe that the 2 more staff will be created. Is that correct? I looked in the bill, but it doesn't really break out what the funding is going for. Could somebody remind me what that was?
Mr. Walls.
Madam Chair and Representative Finke, in the governor's budget documents, when agencies are coming forward with requests, they do list what the FTEs or full-time equivalents are. And so on the spreadsheet column for human rights on the top of page 3, you will see additional FTE. So that's supposed to represent the number of people that will be hired if the agency gets this amount of money. However, we do not specify that in the bill. It's just sort of taken that that's what the money would be used for.
Great.
And I don't know if that answers your question.
Representative Finke.
Thank you, Chair, and to staff. That does answer my question. And the reason I'm just kind of curious about how that's all going to play out is I know that we have a hate crimes bill that's coming forward. We also know that bias-motivated crimes have been dramatically increasing across Minnesota for the last 5 years and in the state, and a dramatic underreporting of those based on what we know from the data. So I just want to make sure that, we're giving a lot of money to the judicial system, but I want to make sure that we're also making sure our funds are there. So we are representing everybody that we need to do. And I also want to just do like a context setting for pay increases, right? Because when we talk about salaries, we often are comparing ourselves to the people around us. And we've heard many times over the course of this committee that judges need increases because the work judges do is very important. But I think the work that everybody in my life does is very important, and I've never had a salary in my life that is even a third of what our judge's current base salary is. So it's hard to hear that the importance of the work demands increases, when I think the importance of many people's work demands increases. They just don't have an opportunity to come and tell us why. So I'm not opposed to those increases. I just want us to understand that that's a lot of money.
Yes, thank you, Representative Finke. And I think it's also sometimes a little bit complicated because you've got the Supreme Court box and numbers, you get the Court of Appeals and then the district court judges. And as we just heard, they have over 300 district court judges. So that number ends up being really big when we're talking about increases at that scale. Representative Johnson.
Chair Becker-Finn, I wanted to thank Mr. Bodell and Mr. Greenman for the work they do. I've actually worked with many guardian ad litems in my career in law enforcement. Unfortunately, I've been the person that's actually had to remove children from a home. It's not a fun thing to do. But the work that the volunteers do in the guardian ad litem program is fantastic. I've worked with the paid and I've worked with the volunteers. I'll take a volunteer any day. They're not doing it because they're getting paid. They're doing it because of their passion for the kids and making sure that they represent the kids' best interest, looking at all issues. To end this program would be a tragedy. We need to find a way to fund it.
All right, I thank you for your comments. Representative Scott.
Thank you, Madam Chair, and thank you to staff for working so hard to put this all together, probably over the weekend. I do have a question for Mr. Walls, and I had a question regarding the capital investment project that's within this bill, in the Judiciary bill. It's I'm trying to find the line item. It's the where they're doing the demolition and rebuilding of.
117.
I'm sorry?
117.
Item 117? Yes, House File 774. And I'm just wondering, have we gone down this road before of having a capital investment project in the Judiciary Finance Bill?
Mr. Walls.
Madam Chair, Representative Scott, I don't know the complete history going back to the infancy of the legislature. In my time here, I'm not aware that we have funded a capital project or a local project. The chair does have some discretion as to what they can spend the money on, but I'm not aware of a similar project.
Representative Scott.
Thank you for that answer. And Madam Chair, I'm just wondering why that provision is in the Judiciary bill, if you could explain that.
Yeah, thank you. I thought it was a really worthy project, and as folks know, and maybe the public doesn't hear this as much as we do, a lot of the funds that we have available this year are one-time funds. I thought that it was a worthy project that was going to keep kids safe. And I think they're also a great example of a project in rural Minnesota where it's really needed, that we're making sure these kids are protected and have, that prosecutors have the resources they need to be able to prosecute these cases. So was my call as the chair, and I'll stand by it. I think it's a worthy project and a relatively small number in the overall budget to make sure that we get this done.
May I go?
You represent Scott.
Thank you.
Sorry.
Thank you for that explanation. I'm just wondering why you just didn't put it in the bonding bill. It's and free up the money for something else. I am concerned about the precedent that it might set. Oh. So, I mean, I know you explained yourself, but I just, was it even ever considered to be in a bonding request? Because no one's disputing the worthiness of that program and what they do. They do great work. It's just putting it in this bill.
Yeah, and Representative Scott, I appreciate that. I mean, the bill was heard in the Capital Investment Committee, but as folks know, the Senate killed the bonding bill. So there's really no, we have no guarantee that a bonding bill is going to get done this year, and I did not want to see this project wait.
Thank you, Madam Chair. And if I could just make some other comments on the bill.
Go ahead,
That's all
Representative
right.
Scott.
Thank you. You know, I don't dispute or argue with increasing the budget to the courts on many levels. What I do have a problem with is a 56% increase in the budget for the Department of Human Rights to hire an additional almost 27 people. And contrary to what Representative Finke's comments were saying about these types of crimes increasing, this isn't tracking crimes. This is a reporting bill. It's only going to be reporting those things. There's no investigation, as we heard earlier this week, that will be done by law enforcement. So, and then we're going to base data and decisions. We're going to base decisions on the data that's collected through that reporting. And I feel like what we're doing with this is sort of weaponizing government. And I have a real problem with that. The rest of the bill, I could probably live with, but this is the piece to me that is most troubling. And I'm encouraging my members to vote no on the bill. Thank you.
All right. Any further discussion? Representative Johnson, it's typically in this committee, I don't give people a second crack at it, but if you will be respectful of me allowing you this one exception, I'll let you proceed.
Chair Becker-Finn, I appreciate that. I wanted to go back to what Representative Scott had dealing with the capital investment program. I also have done those programs. The child advocacy centers are fantastic. They're needed. But I was going to say, I wish the money would be in the public safety side of it, in the OJP program, which is where I had funding for in the past for the same type of deals, setting these programs up and keeping it out of the judiciary.
Your opinion is noted. Any further discussion? All right. Well, we will wrap up. Give folks, sorry. Oh, Representative Carroll.
Thank you, Chair. I just wanted to thank Judge Moore for coming and for taking on the issue that he did. He is former colleague, inter-office colleague. He was with the city attorney's office while I was with the county attorney's office. And I know him to do great work. He also happens to be a constituent. And so I just wanted to give him a shout out.
Fair enough.
And you as a former law clerk.
We know Representative Carroll, but thank you. You always got to give your constituents a shout out. All right. With that, members, we will adjourn and we'll be back on Thursday to mark up the bill.